Getting served with divorce papers is pretty unpleasant. If you've just been served, you're probably wondering what you should do next. Hi, I'm Max Ruthenberg-Marshall, attorney and founder of Porchlight. In this video, we're going to be answering the question of what you should do when your spouse files for divorce. So first of all, don't freak out. You have 30 days from the time you're served to file an answer with the courts. We're going to talk about what you should do during those 30 days in just a minute. But the other reason not to freak out is there really isn't much advantage to filing first. Some people seem to think there is. I don't think that actually holds true, and I think often filing first can set a high conflict and detrimental tone for your case. So for more information on why we don't recommend that our clients run out and try and file first, see our video on whether or not you should file first. So you're probably in a little bit of shock. You may need to take a moment to calm down, take a walk around the block, get a drink of water, gather your thoughts. That's cool. Take that time that you need, but pretty shortly after you've been served, you're gonna wanna read the paperwork. So first of all, you're gonna wanna see what your spouse is alleging. There isn't a ton of detail in that initial petition for divorce, so there's not gonna be too much there, but it'll give you the general broad strokes. The other important document that exists in most counties is the standing order. This requires you to do or not do certain things while the case is pending. So for example, it may say that if you've moved out of the marital residence and your spouse is still living there, you're not allowed to cut off or just stop paying the utilities because they don't want to leave your spouse high and dry without any utilities. Also, it often has restrictions about whether or not you can take the kids out of the state during the divorce process. Sometimes you can't take them out of the state at all, and sometimes there are exceptions for vacations. So there are a lot of provisions like this. The order varies by county, and you're gonna wanna read the standing order that you've been served with so you know what you have to do and not do while the divorce process is going on. Once you've read that paperwork, you're gonna wanna start calling attorneys. An attorney is gonna help you with the necessary steps to file your answer during that 30-day period and let the court know that you're participating in the divorce process. I recommend starting your search for an attorney sooner rather than later. This is for a couple of reasons. First, you're probably not going to be able to get on the attorney's calendar right away. Attorneys have other cases and they may be in mediation or court and just not available to see you immediately. So you'll want some time to set up that appointment. Second, you may not love the first attorney you talk to, and it's really important to have an attorney who is a good match for you. So if you don't love the first person, you're going to want to set up another call and talk to another person until you find someone who is a good match. Third, once you've met with the attorney and decided you do want to hire them, you still have to retain them. They have to write an answer for you, send it to you for a review, and then file it with the court. Sometimes they're also going to be filing a counterclaim, which can require your notarized signature, so it may take you some time to coordinate the logistics of signing the document in front of a notary. All these steps still need to take place within that 30-day window. So I recommend you get started on finding an attorney pretty early in the process. Do not wait till day 25, 26, 27 to start looking for an attorney. In addition to filing an answer with the courts, one of the early steps you're going to want to take is gathering your financial documents. First of all, you're going to have to fill out a document with all this information called a Domestic Relations Financial Affidavit, or DRFA for short. So you want to have the information handy and make it easier on you. Second of all, you want to know what the information says. You're going to need to start planning financially for your post-divorce life. So you want to really have an accurate picture of what's coming in and what's going out in terms of your assets and debts, what liabilities you have, what assets you have, how things might get divided. Your attorney can help you sort through this paperwork and talk about what reasonable financial settlement terms are for your case. Now, just because your spouse filed a contested case doesn't mean that you can't still have an amicable divorce. You won't have an uncontested case because in an uncontested case, you and your spouse sign all the documents, agree on all the terms before the case is filed in court. But even after the case is filed, depending on what attorney is on the other side, the attorneys can usually work things out in an amicable fashion and not go through the most painful and contentious pieces of the litigation process. So if that's a strategy that you're interested in, it's definitely something to bring up when you're meeting with potential attorneys, that's the approach you'd like. You're going to want to look for someone who focuses on amicable resolutions and keeping their clients out of court, as opposed to someone who focuses on high conflict litigation and litigating everything to the max. If you've been served with divorce papers but you want to resolve your case amicably, Porchlight is here to help you get through the process as painlessly as possible and avoid court.